Good morning, everybody. Thank you so much for that kind introduction. It's true, Time Magazine they have this 100 most influential people in the world list, and somehow they put me on it. And I'm from a family of 7 kids. There's 6 boys, 1 long-suffering sister in my family. And I got a phone call from one of my brothers when that came out. He said, "Bob, it's quite a promotion making the 100 most influential people in the world list because you're not even the most influential person in our family." And as for the stranger cover, I mean, I never heard the end of that with my brothers on that one. But it's great to be here back in Federal Way. I actually was just having dinner here last night at Vince's, the Monday night special at Vince's, with one of your local elected officials, Mike Flecciati, who's a good personal friend of mine. He actually worked in the AG's office before he ran for state legislature. So I was at the Kent Rotary this morning and then zipped over afterwards. So it's great to be here with all of you. And what I'm going to do is just speak for a little bit about the office and a few things we're working on, and then open up to any questions. I think there might be some questions that have already been passed out, but I'm happy to take additional questions as well, just from the floor. And feel free to ask about, really whatever's on your mind, whether it's the topics I touch on or really anything else. But one thing I do want to do is provide a sense of the Office of the Attorney General. We have been in the news a lot lately, primarily because of litigation we have against the Trump administration. But we are a big office that does a lot of work besides that, obviously, and I'll touch on some of that. But I'll touch a little bit on the national stuff as well, and then really open up to your questions. One thing I should mention before I get started is that my predecessor is Rob McKenna, and I've known Rob since I was in college at the University of Washington. Rob was student body president at the University of Washington a few years before I became student body president there. So that's when I met him. And then he later went back east to law school. I later went back east to law school. Then he came back to King County, went to work for a large corporate law firm in King County. He practiced there for 5 years. I later came back to King County, went to work for a large corporate law firm where I practiced for 5 years. Then Rob ran for the King County Council. He got elected on his first try. He served for 9 years. I later ran for the King County Council, got elected on my first try, served for 9 years, and then followed Rob to become Attorney General. And everybody was really curious what Rob was going to do after leaving public life 5 years ago. But nobody was more interested than me and my wife. We were the most. We were especially interested. So this is a true story. When Rob was trying to decide what he was going to do, I would text him periodically, and I said, "Rob, we're at the point in our professional relationship where you have to run your career decisions by me. I have a say now at this point to what's happening next." So Rob works for a law firm now. I see him a lot, and I mention that also in part on a serious note because we're the largest law firm in the state of Washington, the AG's office. We have 600 attorneys, 600 professional staff, 13 offices all around the state, every corner of the state, because we have to have a presence in every county courthouse around the state. It's a big office. And when I talk to my team about the work that we do, the quality that I most want, and I give this talk every year to the new lawyers who come in, besides doing good legal work, obviously, but the quality I most want in doing that excellent legal work is independence. Our job is to defend and enforce Washington state law. We need to do that in an independent fashion. Our job is to represent the state, and sometimes we represent defend laws that I don't personally agree with. We have a death penalty in Washington state. I've been opposed to death penalty my entire life. We have lawyers in my office who handle appeals, habeas appeals, federal appeals from cases brought by local prosecutors where the death penalty is involved, and we defend that. That's the job. My opposition is well known. The first week when I became Attorney General, I sat down with the lawyers who do that work, and I said, it does not matter what I think about the death penalty. Do the work you've always done, do it well. If there's a case we need to talk about, come talk to me like anybody would, but otherwise, go forth and do your work. It doesn't matter what I personally think. We defend and enforce state law as adopted by the legislature, the legislative process, or the people through the initiative process. Now, that does not mean that everybody agrees with every decision I make or that Rob made or Chris Gregoire made. I get that, of course. But we need to do that in an independent fashion. That's critically important. And Washington State, the AG's office, has had a long tradition of being viewed as really a top AG's office around the country. And I think it's because of that independence. One last thing I'll mention is after I became Attorney General, I replaced Rob. We're different political parties. He has 5 deputies who oversee the entire operation of the office. These deputies are the closest advisors to the Attorney General, the top lawyers in the office. I did not know these individuals, as you might imagine, and I asked them all to stay on and serve under my administration as Attorney General, which thankfully they all agreed to. What I found out later on was that Rob followed Chris Gregoire as Attorney General. They're different political parties. Chris Gregoire is a Democrat. Rob had asked all of Chris Gregoire's deputies to stay on and serve under him. So there's a fellow who retired not too long ago. His name is Rob Costello. He served as a deputy under multiple AGs of different political parties. I'd be willing to wager a lot that that's unique. I mean unique as in no other AG's office could claim that there was someone who served for that long of different administrations of different political parties. Typically when someone comes in, a governor or an AG, you clear out the folks who were there before, particularly if they're of a different political party. We just don't do that in our office. The line attorneys keep working regardless of administration. The professional staff keep doing what they do regardless of administration. You know, that's how we operate. And it's important to us and important to me personally to continue that ethic of independence, which really has served us so well for so long. So I'll talk about a few issues that are going on. One that you mentioned in your introduction was the opioid epidemic, which I want to touch on. Let me just start by giving you two statistics to sort of set the stage for the opioid epidemic that we have in our state. On average, every day in Washington State, 2 people die of an opioid overdose. That's on average every day. People die of an overdose. The amount of opioids going out into our community it's staggering. I think in 2012, 2013, one of those years, I forget the exact year, we have data for the amount of opioids that have gone out in the community. In that 1 year alone in Washington State, there were enough opioids prescribed for every man, woman, and child in our state to have a 16-day supply. You know, it's devastating. It does not, the epidemic does not care about socioeconomic status. It does not care if you're in a red county or a blue county or a purple county. It doesn't matter if you're rich or you're poor. It doesn't matter the color of your skin. And none of that matters, right? It's truly devastating. When I talk about this epidemic all the time now, I'll talk about a couple ideas we have to address it. There is not a time when I speak about it, or after I'm done speaking at an event like this or a Rotary Club, where someone doesn't come up to me afterwards and say, Bob, can I talk to you for a second? And they kind of want to pull me aside. And I know exactly what they're going to say. My son, my daughter, my spouse, my employee, they're addicted, they've died. It happens every time, every single time, without exception. And that is not an exaggeration at all. I mean, truly, we have 9-year-old kids, my wife and I. If I had to pick 2 things maybe that most fear, right, with them in their lives is addiction issues, right, and mental health issues. Those are the 2 things that you can't tell when they're 9, right? They look perfectly healthy, right? They're doing their thing, but I just know, right, those things cut across all kinds of barriers. Doesn't matter how good a parent you are, how involved you are, my goodness, right? It impacts families all across our state. So, you know, we're trying to do something about it in the office. We have great partners and we work on it. I have 2 ways primarily, I can engage on issues. I've got litigation. I can file lawsuits, right? And I can also, as Attorney General, make policy proposals to the state legislature. They go through the normal legislative process, but it's called AG request legislation. Just like the governor can propose bills, you've got to get your sponsors, right? And the governor's got to sign it, but I can propose those and work on those bills. So on the litigation front, a couple months ago, we filed a lawsuit, the AG's office filed a lawsuit against the largest manufacturer of opioids in our country, that's Purdue Pharma. They create Oxycontin, for example, is their product. You know, I'll spare you the details on the lawsuit, but happy to take more questions about it. But it's a big, big lawsuit. You sue Purdue Pharma, they've got resources. They're not messing around, right? The good news is I'm not messing around either. And I don't like losing, and we don't lose many cases that we bring in our office. But it will be a lengthy, protracted legal battle. To give you just one example of the conduct that I find so outrageous with Purdue Pharma is that part of our case is saying that, hey, they did not make clear when they put Oxycontin out there of how addictive it was, even though they knew how addictive it was. They minimized the addictive qualities of it. To such an extent that years ago, doctors started contacting Purdue Pharma because patients were coming back who looked like they were addicted to these opioids, wanting more. And so we have communications from doctors to Purdue Pharma saying, hey, you said this stuff wasn't all that addictive. We've got patients coming back and, hey, they look like they're addicted. What's going on? Purdue Pharma coined a term for that. They said, no, those folks aren't addicted. That's something they called pseudo-addiction. Not making it up. They called that pseudo-addiction. Those people aren't really addicted to those opioids. That's pseudo-addiction. What they are is they're in pain. They're showing symptoms of pain. So you only get one guess what Purdue Pharma told those doctors to do to treat that pain. Give them more pills. That's a hard thing to say about a company, but it's true. It's true. If you ask me how those executives sleep at night, for the life of me, I do not know. But we'll hold them accountable for that. You know, we're going to do that. And then on the policy side, I proposed 2 bills to the legislature this year. We've been having hearings. One of those is to have pill limits. These would not apply to folks who, if you have cancer and ongoing pain where you need opioids on an ongoing basis. There are common sense exceptions to this, but think of an example of you get your wisdom teeth taken out, or your child, your teenager gets the wisdom teeth taken out. Do you need a 30-day supply of opioids for that?
No.
You do not. Part of the reason why every man, woman, child had a 16-day supply in 2013 is because 30-day supplies are going out for things that are relatively straightforward, like wisdom teeth. One of 2 things is going to happen to a 19-year-old who gets his or her wisdom teeth out and gets a 30-day supply. Either they'll take all those pills because their doctor gave them to them, and they think that's what they're supposed to do, and that's not a good place to start, right? Or they'll take 4 or 5, pain's gone, and they put them in the bathroom cabinet. And now a sibling or a spouse or a guest or a burglar who comes into your house has access to those pills. Neither of those outcomes is a good one. So we're proposing pill limits for situations like that. Look, even those kind of common sense proposals have challenges going through the legislative process. As the politicians here, know, right? It's not easy to get anything through the legislative process, but organizations will oppose these things, which I think is unfortunate. But we have 2 bills, that's one of them, and happy to chat more about the opioid epidemic, but it's a big one, and it's become an increasing focus in our office as well. Another thing I'll talk about the work that we do, so that sort of touches policy things I can do. I can file lawsuits. Another thing that we do is we give what's called legal opinions, an AG opinion. And this happens when a member of the state legislature or a prosecuting attorney, folks can ask us to give a legal opinion on a topic that's out there that the state might need some clarity on. So I'll give you an example that touches on Federal Way as well. I believe, and the mayor is going to help me if I get this wrong, is in Federal Way, the business cannot sell marijuana in Federal Way. That's correct, great. So a big issue after Washington State legalized marijuana was do all local jurisdictions, like Federal Way, like counties, do they have to provide for the sale of marijuana in their local jurisdiction? Or can they say, like Federal Way has done, can they say, you know what, for reasons that we believe we're not going to allow businesses to sell marijuana? Now, the folks who proposed the marijuana initiative had very, very strong views about this, obviously. They felt every jurisdiction was required to sell marijuana. But it wasn't clear, and jurisdictions started opting out and not selling marijuana, and there was some uncertainty. Well, what's the state of the law? So we were asked to give a legal opinion on that. Now, our legal opinions are not binding on a court, but it is rare that a court does not agree with them. I guess I'd put it that way. And so we were asked to give a legal opinion. I want to be clear, those are not, a legal opinion we give is not a policy statement. I'm not saying in that legal opinion what I think the law should be, right? Or what's a good policy or bad policy. I'm simply saying this is what the law is, in our view. We looked at that and we came to the conclusion that local jurisdictions under the initiative did not have to provide for the sale of marijuana. They could ban the sale of marijuana if those local jurisdictions wanted to. I won't go into too much detail, but at its essence, local jurisdictions, your cities, your counties, have the most control to set rules and regulations as they see appropriate. It used to be on the county council. Counties and cities have a lot of authority. They're closest to the people. That's the way it works, right? You have a lot of authority at the local jurisdiction. States, however, can override, preempt that local authority in limited situations, but the state has to be very explicit. In other words, the state has to say, hey, Federal Way, hey, cities, you must do X or you cannot do Y. It's got to be very explicit to override that normal presumption that local jurisdictions can do what they like. So what we did was we looked at the language of the initiative. Is there a sentence in that initiative, marijuana legalization issue, that says all local jurisdictions must provide for the sale of marijuana, period? It's not more complicated than that. That sentence like that would be preemptive, would be telling the mayor, hey, no, you don't have an option here. You've got to allow businesses to sell marijuana. We don't see that language in the initiative. So our opinion was, no, jurisdictions can opt out if they want. Again, not particularly popular with a lot of folks, but we felt that was right under the law. Now, there have been a lot of lawsuits from businesses in the many, many jurisdictions that have banned the sale of marijuana, suing those local jurisdictions saying, hey, I've got a right to sell marijuana here. Those have gone to court. So far, every court has agreed with our analysis that local jurisdictions can ban the sale of marijuana. I think that was ultimately decided by our state Supreme Court. I think it's right in the law. I also think, it's not the reason we issued the opinion, but I also think it's right if one wants to preserve marijuana legalization in our state or around the country for the following reason. First, every state that's legalized marijuana allows for local jurisdictions to opt out, just as a side note, number one. Number two, I'm convinced the reason is the following, that in the lawsuits that we've seen in Washington State, where a business sues a local jurisdiction, the local jurisdiction has two defenses. First, they say, hey, we don't have to allow for the sale of marijuana because that Ferguson guy got it right. State, right, that's state, that's what they say, that state law does not preempt us from doing what we want to do. That's their first argument. But then they have an alternative argument, like lawyers often do, right? They say, well, hey, court, if you disagree, though, if you think the state has preempted local jurisdictions and insist that we sell marijuana, we have an alternative argument. We say then that we, the local jurisdiction, is arguing, well, then federal law, which bans the sale and possession of marijuana, preempts state law. Now that, you only get to that issue if a court first says you've got to sell marijuana, federal way's got to sell marijuana. If they get to that, then they've got to address this issue whether federal law preempts state law. And that decision would ultimately be decided by the US Supreme Court. I'll let you decide what you think the US Supreme Court would do on that issue. But that would be an existential threat to marijuana legalization, not just in Washington, but in every state. In other words, if the US Supreme Court ever got around to saying federal law preempts state law from legalizing marijuana, well, that's the game changer. So that's an example of, when it comes to marijuana legalization, the work that we do in our office. We're obviously, there's a lot going on now with the current Attorney General and recent decisions by him, which I'm happy, if you're curious about what's going on, I can tell you more about marijuana legalization than you probably ever want to know, but it's a really interesting issue, it's an important issue. More and more states are legalizing. I think I just read the state of Vermont, the legislature just, is that right, I think I just saw the headline, state of Vermont just legalized. So this is only going in one direction, but there are a lot of tricky legal issues and relationships with the federal government that are going on that I'm happy to chat about. I guess I'll just conclude by maybe talking about a little bit of work we're doing on the federal side with the administration in terms of litigation, which is, a lot of people are interested in. It's a big subject, so I'll keep it relatively short. Where to start? I guess first, my office has filed 19 lawsuits against the current administration. That's a lot. Some people are less enthusiastic, some are more enthusiastic about that. The first one was filed a year ago, almost exactly a year ago, I think. And we were the first state to file a lawsuit against the Trump administration, as many of you know. Right now, it's very common, many states get involved. Back then, when I challenged the travel ban, no states joined that case. We called around, and then nobody, we're kind of on our own on that first one, to put it mildly. And, I've often thought back to that. The travel ban was signed on a Friday night. Saturday, we were all at the office working on it, and Saturday was the day I decided to challenge it, and I had a conversation with my Solicitor General, Noah Purcell, great lawyer, my Solicitor General, and went to Franklin High School, University of Washington, Harvard Law School, editor of the Law Review at Harvard, clerked on the US Supreme Court, was practicing law at a private law firm as a young associate when he agreed to come work for me as Solicitor General. Think of him as the top lawyer in the office. I think when I hired him, he was like 33 years old. He's quite brilliant, quite a brilliant guy. So we were talking about, whether to file the lawsuit or not, and, we knew it would be an important case, of course. We're suing the president, but, I just got to be honest with you. Neither one of us had any sense of scale of how big that case would become. Believe me, by a factor of, I don't know what. I mean, we're still taken aback by it to this day. Also, if you'd asked me at that day, hey, Bob, how many lawsuits do you think you're going to file over the course of the year against the administration? I would have said, well, maybe another one or two. Maybe that'll happen, right? There was no plan like, hey, we're going to be on some mission to take on the administration. But I have a very firm belief that everybody is accountable to the law. You are, I am, and the president is. Everybody is. That's how it works. And of those 19 lawsuits, 6 of those cases, we have decisions. We've won all 6. 5 of those cases, 5 of those 6, the appeals are over. The cases are done. There are no more appeals. We've won. The 6th one, we expect them to appeal. But we haven't lost one yet. And, we won't keep a perfect record any more than any football team does or basketball team does. But, I think the record does indicate that I try to be very, very thoughtful about any case my office brings. But I think it's fair to say if you're suing the president, and I'm doing that on behalf of the people, I don't call the governor or the legislature to ask permission, right? That's a decision I have to make on my own. And I recognize that, people have strong views about those lawsuits. Not everybody agrees with what I'm doing. I get that. And I'm doing that in everybody's name, essentially, right? I'm doing it on behalf of the state. So it's important that I'm thoughtful about how we do it. I can tell you, we have a meeting every week. There's a team that meets every week. We have more conversation than that, obviously, but there's a formal meeting we have every week where we talk about our litigation, potential litigation, what's going on, working with other states. And, basically making the decision, it's relatively straightforward. The 3 questions I always ask are the following. Are Washingtonians being harmed? That's number 1. Do we have good legal arguments? And third, can I as Attorney General bring the lawsuit? Do I have standing to bring it? So take the travel ban. Someone who's a Washingtonian going to school at the University of Washington, who's traveling, who's turned back at the airport because they're from one of the 7 Muslim majority countries, well, they obviously have standing, right? They personally are being turned away. They could file a lawsuit. It's sometimes less clear whether an Attorney General can bring a lawsuit on behalf of the people, right? So that's a whole separate issue that we have to be mindful of as we bring these cases. But the answer to those questions are yes, yes, and yes. Washingtonians being harmed. We think we have good arguments, and I think I can bring the case. Well, why would I not bring it, is the way I look at it, right? I feel it's my job at that point to do it. And the key, though, it's tricky, right? How good are those legal arguments, right? How good are arguments about having standing? How great is the harm to Washingtonians? Look, there have been cases where we thought we had great legal arguments and I had standing to bring it, but the harm to Washingtonians is a little attenuated, right? Could I have brought it straight face? Absolutely. And even one, yeah, but okay. The harm is greater in some other state, and we'll let those states handle that. That's what they want to do. So each case is different, obviously, but those are the factors that I look at in deciding, how to handle it. Last thing I'll say about them, take your questions, is, all those lawsuits. There's obviously important constitutional issues involved. There's important federal laws that are being interpreted. But in my view, for each of those cases, there are, I think, just important determinations of who we are as a people involved in those cases. So as one example, in the case with Dreamers, which is going on now, there's a big debate in Congress about the shutdown of government and Dreamers and what's at stake there. There's about 800,000 Dreamers in our country, about 18,000 in Washington State. As you know, Dreamers are individuals brought to our country as children through no fault of their own. They have to go through, meet certain criteria to have the protected status that they have as Dreamers. The administration a couple months ago said they were going to rescind those protections of those Dreamers effective March 5th. We filed a lawsuit challenging that. So an important case, to put it mildly. But one thing you should know about that is that in order to become a Dreamer, you have to meet certain criteria. It's not easy. But the first step is you have to come out of the shadows, right? By definition, you have to provide information to the federal government that exposes you to deportation, tells you who you are and where you live. You have to say who you are, where you live, where you go to school, where you work, who your relatives are, who may or may not be documented. You've got to do that. That's the first step. And the deal is the federal government promised we will never use that information against you to deport you. Reasonable, right? Expectation, right? That's a deal, right? It's a deal. You give us this information, you're coming out of the shadows, we promise we won't use that information to deport you. And that's been the deal. In fact, there's even on a federal government website about the Dreamers program, there's a frequently asked questions. One of the questions is, will this information ever be used against me? Answer, no. Federal government won't use that against you. On the day that the President and the Attorney General announced the rescission of those Dreamers protections, that Q&A was removed from that website. Look, I mentioned I'm from a family of 7. I get that there are strong views, differing views on immigration in our country. Believe me, I understand that. I travel the state, I speak to Rotaries all around the state, I get it. But do we as a people, one thing I think we agree on is a deal is a deal. And that to me is an American value. We teach our kids that. My 9-year-old son, if he trades a Pokemon card with a buddy and he realizes afterwards, whoa, I gave away a really valuable Pokemon card. I didn't realize how valuable that was. I made a bad deal. And he comes to me and says, Dad, I want to get my Pokemon card back. I'm going to say, no, Jack, that's not how it works. You made a deal, you made the trade, you got to live with that. What kind of a country says, hey, give us your information, we promise we won't use it to deport you or your family members, and then goes back on that deal? I don't care what everyone thinks about Dreamers or immigration. A deal's a deal. That's how it works. And that's at stake in this case, in who we are as a people. And that I have found to be the case in each of these lawsuits that we brought. There's always something there that I feel very strongly about. Besides the law, there's a story behind every case, right? And I tell my team all the time, we need to tell that story to the judges, right, and to the people of my state, because that is why we're bringing these cases. So I've got strong views on the subject. I don't know what the new year will bring in terms of litigation against the administration. I hope we don't file another 19 lawsuits. But if we feel that's what's required, then that's what's required, and that's what we do. So I will stop there to turn to whatever questions that you guys have as well. Thank you so much.
I don't know. I don't think I'm ever going to give up that tiger beat thing. Okay, so we have a few.
I'm ready.
Here's one. Can cities join your lawsuits?
can cities join our lawsuits? Well, I wouldn't want to say never, right? But generally, certain authority only I have. So for example, consumer protection lawsuits, right? The law specifically says that's the Attorney General who can bring that, for example. Now, in the opioids litigation, while the City of Seattle did not join our lawsuit, we announced our lawsuit and the City of Seattle announced their lawsuit on the same day. So are we working together? Yes, but are we on literally the same litigation? No. So in general, we operate separately, but there can sometimes be a lot of coordination going on with many of the cases that we do bring.
Okay, thank you. Okay, here's a two-parter. You mentioned this earlier. What does it cost to sue the pharmaceutical companies? Because I assume there's going to be more than one.
Yep.
And what do you hope to achieve from the lawsuit?
So that's a good question. Well, the cost to take a case like Purdue Pharma, if that goes to trial, the cost is, costs millions of dollars to bring a case like that, right? You take it all the way to trial. Some cases resolve early, and it's not much money at all. Couple of things. The team that is doing that work is our consumer protection team. The consumer protection team is probably about 80 people, about 27 lawyers and another 40 or so professional staff, investigators, paralegals. The consumer protection division receives no tax dollars. I mean, literally 0 tax dollars. They are funded by recoveries. They file lawsuits, they get recoveries, that self-funds the operation, in addition to returning tens of millions of dollars back to Washingtonians who've been harmed, in addition to giving tens of millions of dollars back to the state of Washington for the state to use to fund education. It's one of the few places in state government that is a moneymaker for the people in the state. And again, self-funds the entire operation. It funds my civil rights unit, for example, as well. So the cost of the taxpayers for bringing a case like this would be essentially 0, in that's just what the consumer protection team does. That's their mission, and they don't receive taxpayer dollars to fund that mission.
Okay.
Did I get both parts of that question?
I think so.
Okay.
Here's one. Regarding immigration, what role will your office take representing Washington versus the Trump administration?
On immigration, I think I've touched on the Dreamers litigation, which is sort of the main thing right now. I guess, and by the way, I should mention on sort of cost to taxpayers, on those 19 lawsuits, the work being done on those lawsuits is being done almost exclusively by the consumer protection civil rights units, which are self-funded. They don't get general fund dollars. Obviously from time to time we go get advice from an attorney who works in a division where there's tax support for it, but that would be a very small fraction of the cost of that. So essentially the work we're doing, there are not taxpayer dollars involved. In terms of immigration in general, so the Dreamers case is the big one that we have right now. To give you just a quick update, there's a hearing on that case on January 30th, which is next week. Does that sound about right? That's next week. That's a big hearing, and before a federal judge. That's an example of a case where sometimes we file cases on our own, travel ban. That's our own lawsuit that we're bringing Washington on. So other states later joined us. The immigration case, Dreamers case, that's a case that we worked with other states. So one of our attorneys will be making the oral argument back in New York, but we worked with New York and Massachusetts in particular, sort of a team effort. Other states have joined. But what you see more and more now are groups of states filing lawsuits in which there will be a lead state that does the bulk of the work. Other states will assist, but that helps on the resources. So when I say there's 19 lawsuits, we are by no means the lead state on all 19. Yes, we are on some, and those are resource intensive, travel ban being a good example. There are many others where another state, New York, is leading it. Yes, we help, we're reviewing briefs, we're adding things to it, but it's far less resource intensive than leading it.
Wow. Okay. We cannot watch mainstream media discuss a federal judge without mentioning which president appointed him or her. Speaking generally, what type of bias do you actually see? And is there a diagnosable trend and difference between liberal and conservative? Or is this overblown and exaggerated with each judge interpreting the law within their allotted discretion?
That's a good question.
It's written down if you
that's a good question. That's a good question. I guess a couple thoughts about that. So obviously I have a lot of experience with the federal courts, but also after I finished law school, I was a law clerk for 2 federal judges. So each federal judge can hire 2 or 3 law clerks who help draft opinions, do the research on all the cases that the federal judge is dealing with. So you work very, very closely with that judge. I mean, you are elbow to elbow every single day. I mean, And you have to sort of get in that judge's head too, as you draft opinions, you have to be able to write them in a way that the judge wants, obviously. And so I worked for one judge who was appointed by a Republican president and one judge who was appointed by a Democratic president. I guess what I would, and they were very different people. I guess what I would say is that, federal judges, yes, you often see who was appointed by who. I think people just want to know that, but I guess what I would say is that the federal judges are people, right? They bring their own life experiences to everything they do in the same way that you do with whatever you do with your life, right? That's just, we're people, right? Now, are my judges saying to me when we get a case, hey Bob, I want to rule X, even though X makes no sense under the law, figure out a way to do it? No, that's not what's going on. Did those two judges have different orientations, I think, in their worldviews? Were they different politically? I think they were. And that's going to reflect itself in certain ways. In the same way that, hey, I'm a Democrat, Rob McKenna was a Republican, we're leading the same office, but my priorities might be different than Rob's priorities in certain areas. And some they overlap, and some they might be different, right? But the federal courts, in my view as a whole, no, they're not politicized. When you go in there to make your arguments, you're just making your arguments. I mean, that's what you're doing. You're focused on that. And I think that's encouraging. One thing that has been discouraging to me is, on the travel ban case, Judge Robart, Western District of Washington, was the judge we were assigned. It's a random drawing, by the way, that you cannot pick a judge, just to be clear. You can know what district you're filing in, but then there's a group of judges by which they have a random system to pick a judge. So you don't, I think some people think, you go pick a judge. No, it doesn't work that way at all. You can pick a court to go into, but not the judge. So we had Judge Robart, who was appointed by George W. Bush, if I recall correctly, a Republican president. And it's, in a way, at the time, in a way, I was glad that we had Judge Robart. He's known to be a very tough judge, very smart judge, but fair. That's his reputation. In part, I was glad because I was obviously hoping we'd win, but I didn't want folks to say, oh, he got some liberal judge out in Seattle, right, to hear the case. So I think there's a public perception that it matters more than it actually does, would be the way that I would look at it. And just give you another example is, so I think it is overblown, maybe there's questions there. As a good example, on the first travel ban, we won the district court. It was appealed, the Trump administration appealed to the Ninth Circuit. We won there 3-0. And the Trump administration could have appealed to the U.S. Supreme Court at that point, right? The U.S. Supreme Court is not viewed currently as a liberal court by any stretch of the imagination, obviously, right, by court watchers. So he could have appealed to the U.S. Supreme Court. He chose not to. He chose not to because he would have lost. It didn't matter what the makeup of those judges were. We simply had the better case, and they knew it. They did not appeal it. Is there a factor? I think yes, but only because we're people. People have ways of looking at the world, and that's reflected in everybody and everything that they do. But I think, do I think it's a little bit overblown? I think I do. Yeah.
I just want you to know that you have spoiled Law and Order for me when they go and they pick the judge.
Is that
the case.
Right?
So thanks for that.
The local system be different than the federal system, but yeah, the federal system, it's, yeah.
So those were all the submitted questions we have.
So we'll open up to the floor?
We've got about 10 minutes.
Good.
You want to open it to the floor? Understand you got to sign my thing.
Okay.
And we'll be taking pictures, and I'm sure people want to talk to you one-on-one. So
That'd be
open
great.
questions from the floor.
Who's got questions from the floor? Yes, go right ahead.
Maybe talking about a more bland case.
Yeah.
Could you talk about why culverts are so important, and could you apply your three-part test
Sure.
to this case?
Yeah, that's a really good, that's a big case. So for culverts, just to give a little background on the case for others who may not be familiar with it, very complicated case, went on for a long time, but I'll try and distill it down in about 60 seconds. So it's a case that's has huge ramifications for the state, for reasons I'll talk about briefly. It is of intense interest to tribes in Washington state. So we have 29 federally recognized tribes in Washington state. 21 of them sued the state years ago. I think back Chris Gregoire was Attorney General, give you a sense of how far back this goes. Washington state has culverts which allow for fish passage, right, through where there otherwise be barriers. Culverts are expensive to put in place, and the tribes, I'm going to oversimplify dramatically on this case, it's a very complicated case, but the tribes are saying, hey, we've got treaty rights to fish and access to fish, and these culverts, which are not working, not functioning, right, or not enough of them, you're not replacing them fast enough, are blocking fish, and that's harming us and harms our treaty rights. That's their argument that they made in a high nutshell. The state has been defending that. Chris Gregoire did first, and Rob McKenna, then I inherited the case. I think when I was getting on appeal to the Ninth Circuit. The state's lost at each level so far. The Ninth Circuit issued a decision not too long ago that did more than say, hey, state of Washington, you got to fix those culverts, and you got to fix them quickly. In our view, the Ninth Circuit issued a very, very broad decision that if the tribes applied the logic, the reasoning of the Ninth Circuit case, it would apply to many, many different areas of our life here in Washington State that we don't think is what the impact really should be. And we have a lot of arguments. You know, the culverts that we have, we built them based on designs from the federal government, for example. The federal government said, here's how you're going to design these. We did. There's problems with them. We're saying, well, hey, if we've got to pay for it, I've got to look out for the taxpayers. Well, hey, if you're saying, court, that there's a problem with them, the federal government should be paying for this as well, not just us, as an example, right? Another thing we're arguing is, yes, there's a lot of culverts that need to be replaced. There are many culverts which nobody disputes, even if fixed, would do absolutely nothing to improve salmon. I mean, like nothing at all, because there's more barriers downstream. Or private landowners have land where nothing's happening, or a local government, right? And these are millions and millions and millions of dollars. A lot of money is at stake here with this. So I had to make a decision whether to appeal that Ninth Circuit case to the US Supreme Court. Now, I don't have to do it. That's a discretionary decision on my part. I don't have to do it. You know, I have to defend the state, but at some point when you're appealing, that becomes discretionary. Look, it's, when I talk about independence of the office, maybe this is a good example. I work closely with the tribes in the state. It's no secret, tribes are very influential players to support political candidates who run for statewide office. That's no secret to anybody. They invest heavily, millions of dollars into candidates. They are intensely unhappy with my decision to appeal that case, to put it mildly. So, but I have a duty to the people of the state and the taxpayers of the state, and if I think that Ninth Circuit decision is too broad, you know, I've got to do what I think is best in that role, even though I know that politically it's a disastrous decision. It is. There's no way to sugarcoat that. So now we have had settlement discussions with the tribes. You know, I think we've got reasonably close to a deal, but not all the way. We're open to continuing that. So we'll see. So the Supreme Court has accepted review, I should say that. We asked the court to take the case. They do not take most of the cases that petitioners asked, but they took this case. And there'd be a hearing likely in April. I don't think they've set the date yet. And so at this point, we're going forward with that. And so, you know, we'll see what happens. But you know, maybe it's a good example it's a good example of the important role of the office and that independence. And sometimes it's not easy, you know, but you know, another example was charter schools. There's a big charter schools case that we had. The People Adopted Charter Schools Initiative, of course, and there was a challenge to it. Went through the legal process. The state Supreme Court issued a decision saying no, it was unconstitutional. It was a 6-3 decision. So, you know, in my personal life, I've never been a particularly big fan of charter schools. That's not been a secret. But we're defending the law, obviously. We lost 6-3, and looking at the Supreme Court's decision, the state Supreme Court's decision, the team felt, and I agreed very strongly, that our state Supreme Court's decision went far beyond charter schools. Similar to the culverts, if you applied the logic of the state Supreme Court's decision, it would adversely impact programs like Running Start, for example. If you applied that logic, you would adversely impact all sorts of other programs that have nothing to do with charter schools. So, you know, I made the decision to do something which is very unusual. We asked the Supreme Court to reconsider their decision, which you don't do very lightly, right? You've argued this, you've briefed it, they've issued a lengthy decision, and then you have to say a couple weeks later, hey, Supreme Court, would you reconsider that? Are you sure about that, right? You have to have a strong view. But we felt that there was a footnote in that opinion that, again, would be disastrous for Running Start and other programs. And in other parts of the decision, we asked them to reconsider. Look, it doesn't matter what my views are of charter schools. I've got to defend that and then look out for the other implications of that decision beyond charter schools. So in that case, for example, the Supreme Court did remove that footnote, which was, we think, a big success. One justice was prepared to reconsider the decision, but we needed 2. So the decision went on, right? But that footnote was removed. So we got a partial victory by reconsidering. Look, whereas the Washington Education Association was not happy with me for that decision. Their argument was, hey, Bob, why are you filing this discretionary reconsideration? You don't have to do that. You know, my response is, I hear that, but there are impacts in that decision that go far beyond charter schools. It's my duty to do it. And so, sometimes I'm asked, and I'll wrap up with this, I'm sometimes asked by, in fact, I was speaking to interns down in Olympia. These are college students who work for elected officials in Olympia. I'm sometimes asked, hey, what's the most important quality to be an attorney general? And for me, it is easy, right? It is easy. The most important, you don't have to be the smartest lawyer in the office. There's plenty of smart lawyers in the office who can help you out. You have to be the smartest, best politician. But what you need to have is the ability to make your friends and supporters very, very unhappy. Every single week. Trust me on this, there's not a week that goes by where we're not making a decision, I'm not making a decision, or it's just like, I just know, I just know. But you have to, if your team sees any daylight between what is the right thing to do, and they're not dumb, they know, right? If they see any daylight between that and their sense that you are doing something for a political reason, forget it. First, they'll lose their respect for you, number one. And number two, it's just easier the next time to do it for that reason, right? You can always justify, I don't have to file that appeal, but to me, it's just easier to keep it simple, do what we think needs to be done, and sort of let the chips fall where they may. Hey, thanks so much for having me here today. Really appreciate it. Oh, sorry,
One more question.
oh, great, there's one more. Sorry, I didn't realize.
That sounds like you work for the chamber, so we're going to squeak one more.
All right, excellent. One more.
Actually, it's not a question.
Yes.
But in July, the Ethiopian Soccer Federation had a soccer tournament here. And the Attorney General was our keynote speaker, where over 20,000 Ethiopians were gathered. And they were very pleased, they were thankful for what you've done, and they were amazed at how personable he was. But they also, some people spoke to me and they wish you were still there so they could thank you in person, because the travel ban would have affected a lot of people with Muslim names and Muslim backgrounds, even though they're not from the countries that were identified. They're Ethiopians, but they still follow the religion. So they were very thankful, and I just want to take this opportunity
thanks for
to
saying
thank
that.
you in person.
Yeah, I'll just say that, the whole travel ban experience, I was thinking about this just the other day because after the travel ban, the decision came out, I started getting some letters, handwritten letters, not emails, at the office. People wrote from all around the world, all around the country, and obviously from Washington State. And so when a few came in, I said to my executive assistant, hey, if someone handwrites a letter from my office, I want to handwrite a quick note back. Because people are writing deeply personal letters, I mean, people have strong views about it, and they're writing deeply personal letters. And so I thought there'd be 50 of them. There ended up being, just from Washington, a few thousand of them. It became a big job. And so I started taking them home at night to handwrite these notes back. My team would organize them, and I'd go at night and I'd just kind of write a quick note back to folks. But people are writing, hey, I was born in a Japanese internment camp, and this is what this case means to me. I mean, these are really personal letters, right? And so I'm there, and up to that point with our 9-year-old kids, we hadn't said much about the travel ban, right? I was gone a lot from work, so all we'd said when they asked why I was gone so much was, I just said, look, kids, the president did a bad thing and daddy's trying to stop him. I mean, that was kind of it, and they started, they're too young we thought, to really understand it. But I was there answering these letters, and Katie, my daughter, was doing her homework next to me, and she said, Daddy, what's that? And what she saw was one of the letters, and it was a letter from a kid. So I got a lot of letters from children. And so this was a letter from an 8-year-old girl, Katie's age, from Iraq, if I remember correctly. And the child had drawn this funny picture of me, which was great, and that got Katie's attention. It was clearly written by a child. And what that girl wrote, it was the best thank you letter of all. She wrote a long letter, but what she wrote was, because you stood up, I can be here. And so I was thinking about her yesterday because her father called recently, and so he has 4 kids, that girl being one of them, and they're going to come by our house for a play date with my kids here in the next couple weekends. We're scheduling time. They want to come by, and the kids want to, so it's, it's great for my kids as well, because Katie could then, when she asked, why is this kid writing to her dad, right? She's 9, what's going on? So I explained what was going on, and it was fascinating that Katie could then kind of engage on the issue at that level, and which has been great. So we're gonna have a play date with those folks. It'll be a great time. Yeah. And so I guess I have one last. Are we all done the questions?
Sure, we are.
So I've got one last thing that I understand. I think I need to ask everybody. Is that right? So I understand that Becca often asks that I hear when you're looking for the path to business success, all you have to do is